Good morning. We're getting ready for the long weekend. Hope you make both. Nonetheless, I hope the day well. And oh, today's topic, usual Q&A on family matters. We have started a new system whereby you can pose a question, deal with it at our next webinar. So get this quite a few questions that posed, 4 in total for those questions. Why we do this is pose a question. I will inform you for the time when we will be. That's great. On the screen as well, we can see the Zoom link. If you wish to partake in this webinar, your camera will not appear. Only your voice. I have two cameras here. So you'll be able to see me from the platform. I'll be able to see if you wish to on your camera so that you're on. Then we can engage and you're welcome to whatever. And you can do it live. And at the same time, if you have a question going forward, please feel free to make use of those new. And if you want to interact with me via typing, you can do it via the Zoom. I'll pose a question or make use of the advocate. Well, seems to me many people are shy in the email, but nonetheless, I'll try. But for those who have posed those questions and are patiently waiting, I hope you receive the notification. If not, notification also. Question one: I have a garnishee order for maintenance, which 18. The maintenance is always paid by the 20. The arrears were paid by the father's company full March 20. Since then, no arrear payment. I have also moved like to court with the or if I can go to the court close further lessons to this. Okay, so let us unpack this. There was a maintenance order put in place. At some point, the father never paid maintenance. Garnish order, the order that maintenance paid, and also a part of that years. Let's say, for argument, it was 100,000 and maintenance will be difficult for the maintenance lawyer pays the 100. It's a guy. But nonetheless, what they most probably will do is say, "Okay, sir, your maintenance order is land. I'm here, and every month you pay an additional 1,000 a month and years." This specific scenario, the employer paid the arrears, the capital until 20, and then all payment stopped. Okay. Now the question is, she still has a garnish order in her hands, but she moved. As she approached the maintenance, they granted the garnish order where she put it these. Oh, the maintenance court where she is. Okay. Hope you follow where that is one. So the quick answer is, because she is now in a new jurisdiction, she needs to apply the maintenance. Very important point. The maintenance court where she used to live, or we say no longer to the. It's a bit of a not a complicated issue, but you'll have to the file has to move. So my quick advice to you would be contact the old court for that grant. Determine dealing with files, their names. Go to the maintenance court in your area where you reside. Look into the maintenance Cape Town. They have my file. is a request from one that specific person pays and it's okay. I hope that answers your question. If not, you're welcome to or invite. Okay, but nonetheless, we all know that that form, but that I think gets missed. What does get missed is obviously questions that you pose on later. Okay, let's question number 2. Another question that was posed, I think, today after our last webinar. Okay, question 2. The school I want to enroll my child application. Father does not want to sign the parent form. He says the school is not good and want out remain at the current. He's in grade 3. The new school is much better and costs less. Okay, simple scenario. Child is currently full grade, go to a new 4. Of course, with schools and time of the year, they obviously both got signed verification, and of this documentation, these documents that both people on, and also consenting to the minor child, so there would not be any problem in the process. Okay, so long story short, the father does not want to. The father does not want to cooperate. And the father does not want to cooperate. Need to act for. Next month is November. Week is November. And you need to make sure that childhood knows that you shall attend at school. At the same time, the minor child is currently that you are leaving, you're not coming back next year. Obviously, another child place with it. Therefore, if you and the father cannot resolve it, I advise you urgently approach the. I believe that the children's court may be able to assist the matter. I'm certain if they would be able to assist, have heard, have been to the children's court, deal with these type of guardianship. Adequately how to deal with these type of. But nonetheless, I have previously made this court and I go to hint. But the bottom line of it is approach the court as soon as possible, make inquiries, children's court with us say yes, wonderful. Oh, okay, High Court, and let the High Court will ultimately look at the matter like, okay, mom, you want the child to approach to attend this year. What are the reasons for it? The child is currently attending a school, the child is enrolled in the current school. What are the problems? What are the issues? Why do you say the other school is better? Why do we have to change the status quo? Would it be in the child's best interest? Moving from grade 2 to grade 3, one grade, the child is not going to a high school. Then the court would listen to the father. Sir, why do you want a father says the new school will be better? Why do you say the current school is better? You will have to give reasons for that. If you are the father, explain. On behalf, I will explain that the child is with the child, the teachers know the child has a specific progress in this. The teacher the child has, they know each other, and they put the child at a specific chair or desk in the classroom because they know the child struggles. They know the child excels in specific sport. The child took long to to get into athletics, whatever skills the child has. Now the child goes to a new school, they do not have athletics, so the child's progress in life, whatever the arguments are, need to apply. Mom's argument might be, you know what, I've moved on with my life, we live in a new area, the school is much better, the child has a preference for this type of sports, she does not like music or swimming in whatever. So those are the facts the court has to listen to. If the issue is affordability, if the mother says cannot, father does not want to pay, this is a support. Oh, the case becomes difficult for the father side because he's not contributing, but he wants. So those are the issues which that and the court would ultimately make as to what is what is best for the minor child looking at. Sometimes it's better for minor child not to go to a better school if the current school pointed to the minor child and is closer to where the parents died, and the child would have better contact with the parents family. For argument's sake, there could be a school in Johannesburg and the parents are living in Cape Town. Of course, that school is much better because the granny sorry, Johannesburg is much better because the granny lives there, healthy, and she's the best school. But the parents are living in Cape Town. The mother wants the child to go to Johannesburg. Obviously, on an educational point of view, it's better for the social, emotional point. It's best for the manager. Cape Town with the parents, definitely, but ultimately, what happened? Mother over the father, I would want. Okay, let's go to questions. Another question that was posed previously, I think, yes, we pay got out live. Go to that link, pose your question. Our next webinar, I will deal with it. What I have noticed was if you type out the answer to someone, they do not necessarily understand. Oh, yeah, person is a layperson. Paragraph, saying it. That person might not understand it. However, if you verbally answer, you try to explain it, like you start to speak to the person has a quicker grasp of the issue involved, and the person understands what you're supposed to reading. So therefore, I like this engagement, videos and so on. For the day, the idea is to know what I know you right, so better empowered than you were before. I get many complaints from where they say, I consulted with a certain and I am in no better position for outage. That's the way some people advise. My policy while paying somebody, the person learning benefit. So don't words and question three. I want to divorce my husband, but I cannot afford a lawyer. I also do not know where my husband lives. Last address was our just before lockdown, March 20. He does not pay maintenance. He also does not want to say where he visits the children once. They do not go out. How can I start the divorce process if I do not know? Okay, interesting question. Quite a few issues involved. First issue, divorce. Just to the problem with that is does not know. And in terms of law, want to divorce spouse, you need to serve the spouse. Now there are various ways of doing that. One way, obviously, proper way and usual way. Sheriff, you issue the papers at court. It's taken to the sheriff's office. The sheriff home. The sheriff would obviously serve the summons. Independent husband. If you do not know where the husband resides, then you can service, you can email, potentially via WhatsApp, if he uses WhatsApp. The modern times, maybe via the newspapers, maybe because it's appropriate, workable. Obviously, you'll require the course practice court. So that's the second issue which the mother has or the wife has, issue of the location of the father. Now, the other issues, of course, which I see here is the one of maintenance. He's not paying any child maintenance, and that as well. My advice to obviously approach a maintenance court unless you start a divorce proceeding with something maintenance. But nonetheless, that's a side issue, one which obviously you'll have to attend at some point. Because you cannot get hold of your husband, you need to approach the court beforehand and tell the court, I would like to issue divorce proceedings to my husband. I do not know where he resides. Please give me permission to serve the documentation on him via WhatsApp or via email or via any means which you have verified to the court that it is workable and is used by the defendant husband in the court would have to be convinced that you tried every means, that you have obtained a tracing agent. The tracing agent obviously tried to locate the fathers and cannot do so. The court would want to know from you under oath that you have asked the father quite a few times, sir, where do you reside? Where do you stay? I would like to start the divorce process, but I would need to serve the documentation on you, whatever the case may be. That those are possible options you may have. The other option you may have, which could be most probably a bit cheaper, in my view, and you do not have to do the substituted service application, would be to ask the father, when are you coming to visit again? And if you know he comes to visit every Saturday at 2 o'clock, it might just be cheaper for you to inform the sheriff that he will be visiting this Saturday at 2 o'clock. Please come to our home at 2 o'clock and serve the summons on. That might be the easiest and the most cheapest way of doing it. But if you cannot do that, then obviously you'd like to get the court's consent whether or not you can serve it on him via some other substitute. Thank you for that question. It's a very technical question, and I hope I assisted you where that is concerned. It is possible, but there are some hurdles which you have to overcome. Once you have issued the summons and father has been informed about divorce proceedings, then you can obviously deal with the issue concerning interim maintenance within that divorce court. The High Court, for example, it will be a Rule 43 application for and contact arrangements, and even a contribution towards legal costs as well. Okay, I hope that answered that question, and thank you for posing it. Question 4. Last question. My sister passed away, and she said in her will that I must care for my niece, which is years old. Okay. Father also passed away a few years ago. What can I do to legalize the will as a child and have? Thank you. Very interesting question, and something which I have dealt with in the past. I had to obviously learn at the time was that in terms of the Children's Act, can appoint another party as a guardian to your child if you are the sole guardian to the child when you pass away. So let's say, for example, have a child, the father is no father, or you're the mother, or you're the father, there's no mother, whatever the case may be, and you're the sole guardian of the minor child. And in your will, you can stipulate that at my death, I would like to give the guardianship rights to brother, my aunt, my uncle. And at your death, that specific person would have be the guardian over. The problem or the challenge you might have is you cannot move around everywhere with a will, a photocopy of a will that's been to the master's office and the estate has been wound up. Now, in my specific scenario years ago, what we done was we approached the court and we asked the court to confirm that you are the guardian of the minor child and these are the minor child details, X, Y, and Z. And with that specific document, you can apply for a passport, you can travel with a minor child overseas, you can enroll the minor child into court, basically a rubber stamped terms of will. Of course, we need to legalize it, because otherwise anybody tomorrow can just come with a piece of document stipulating I am the guardian of this specific child. Document a will, but how do you know it's legitimate? How do you know it's legalized? How do you know the other party passed away, and so on? So that's what the High Court will, look at all the documentation. So in an application like that, I would obviously attach, number one, the death certificate stipulating that this person has passed away. I would attach a copy of the will, and of course, the will has obviously been accepted by the master as being invalid. I'll attach the ID document of the deceased, the details of the child, if the child is older and has an ID, attach that as well, my ID document. Just to sort out that whole link, and also the background of the matter, who I am, how my connection to the minor child came about, etc., and why I want to care for the minor child, and the minor child wants to be. So that's basically a simple application, but you have to just make sure that you dot all the I's and connect all the links to the Pacific chain. Thank you very much for all the questions which you have posed. I appreciate it very, very much. Feel free again to make use of our link, www.ourlawyer.co/live. Pose your questions. You will have an option of either to join this, me to answer it either for you live or via Zoom, or you can call in. There's a choice you have. You can pick. I want to have the specific question answered via Zoom, and you can interact with me. As I mentioned earlier on, no one can see your face. Some people do not want their faces to be seen. Some people do not mind. But obviously your voice, and we can interact. If you want a free consultation with an advocate, 10, 15, you're welcome to do so. Yeah, I'll be able. But however, at the same time, welcome to pose a question and the next webinar. Have a lovely weekend. Be safe. Vote on Monday. We have registered, etc. And be safe.